Now, if we haven't generated some questions by now, there's something wrong with your brains. So, any questions? Hank.
So I'm going to rise to Fred's bait. You and I should actually have a debate about this someday, though not today.
Isn't this what's happening right now?
For the sake of everyone else, I don't think we should do the 2-hour version that would probably be necessary. But I want to agree with one thing and then point out the 2 reasons I think you're actually wrong. The thing I want to agree with is the law determines what evidence comes in. That's clear. I don't think that's actually disputable. It's not that if some scientist says this evidence is scientifically valid, the law will automatically put it in. There are all sorts of issues of relevance, privileges, confidentiality. There are all sorts of things that go in that are legal decisions. And subject to some extreme due process boundary, if the law wants to allow in scientifically dubious evidence, the law can do that. I think we would both agree that that's probably not usually a good idea, that the law should be guided in its decisions about what's admissible by what's scientifically valid or not. But scientific validity is not a legal absolute requirement. And I agree with you on that. I think the things we disagree on are twofold. One is, so if I were to ask you whether you would allow a criminal defendant to introduce evidence from a psychic saying that she has seen in the crystal ball that he is not guilty, I'm hoping you would say you wouldn't let that in.
Right?
Okay, good.
The notion that there are degrees of reliability and degrees of validity is not the claim that we should let in things for any purpose that have zero reliability and zero validity.
Good. That's the answer I was hoping to get. I think where you and I disagree is I think you look at the literature on lie detection, and you see something that, well, it might be 60%, it might be 70%, it might be 80%, but there's some pretty good stuff out here saying this works. And I look at it and I see nothing, zero direct evidence that it works in a real-world setting. I see zero direct evidence that it works with people who are interested in using countermeasures. And there is, despite what Steve Lakin said yesterday, a countermeasures paper out from Giorgio Ganis in November of 2010 showing that countermeasures do disrupt significantly fMRI-based lie detection. I'm agnostic about whether this stuff will ultimately be good enough. But I think you're not focusing enough on what the literature actually shows versus what a realistic courtroom use would be like.
I think our disagreement is about the question of zero direct. That is, and maybe our disagreement is about the question of whether construct validity and external validity are variables. So implicit in my view is that construct validity and external validity are themselves variables, and even though there may be differences between what an experiment has been done on and what we'd like to know, we can also do studies to see just how good it is.
So I said zero direct because I do think the experimental evidence is some indirect evidence that in a non-experimental setting it will work fairly well, but I don't have a clue how good that is, and neither do you, I think. Third, last point, the idea of using it in the setting it's going to be used is an interesting one, and I do think it points out a really interesting thing about the political economy of forensic science. Most forensic science comes in when the prosecutor wants it in. Most of it, and most of the really dubious stuff, comes in when the prosecutor wants it in. It's usually the prosecutor who's got the resources and the background and the crime labs and so on to do this. And so it's kind of odd for the defendant to bring in a lot of forensic evidence. And when it does, it makes me feel a little bad that I'm dumping on a piece of forensic evidence that defendants are likely to bring in more than prosecutors. But A, I think the law probably should ultimately be neutral about who's introducing it. But B, prosecutors will use lie detection. Prosecutors will put somebody on with a lie detector that says, yes, I'm the victim, and yes, I'm telling the truth. Or yes, I'm the witness, and yes, I'm telling the truth that this person did that. It's not something that will be just used by criminal defendants. Although that particular application of saying, yes, I'm innocent, obviously is something that will just be used by criminal defendants. And so I'm leery about how much weight to put on the different contexts. I certainly agree with you that the mere fact that it can't be proof beyond a reasonable doubt doesn't mean that it is no evidence at all. That's not in question. But I think you overestimate how different the setting will be for this than for other forms of forensic evidence. But I think our main disagreement is on that second point about just how good we think this thing is in the real world based on the evidence we've seen so far.
Fred, did you want to say anything?
So just one thing that's a lot of for those of you who don't know the debates in the literature, a lot of the debates in the literature about validity are about the fact that, with the exception of some of the research recently done and now being done by Josh Green, most of the experiments on lie detection, neuroscience and lie detection, have been done on instructed lies rather than real lies. The claim, which I totally agree with, is that an instructed lie may not be a lie at all, and therefore we can't infer anything from what people have done about instructed lies. Green's research tries to transcend this with some success so far, although some of it is preliminary. But I think, again, the question of to what extent do we know whether people who are willing to tell instructed lies are more willing to tell real lies is the ultimate external validity question, as to which we have very little evidence.
Yes. I'm asking this both genuinely and a little rhetorically. I have a hard time seeing the practical application of this in the real world of courts as they currently exist. I mean, I'm more familiar with juvenile courts than I am with criminal courts, but they don't have the resources to pay for paper and pencil assessments of kids, much less $1,000 a shot, fMRIs. Moreover, if I'm lying about something, I'm not going to be cooperative when somebody orders me to lie still, in a magnet while they're scanning me. It's just really hard for me to envision how this is ever going to be implemented in a very big way. I mean, the research is interesting, but I'm trying to figure out if it really has practical
And in a way, when you talk about the costs, in a way, this is actually a debate about further away from the cutting-edge lie detection kinds of technology. So there is a Supreme Court case, United States versus Schaefer, that goes back decades, where the question was framed not that differently from the way I framed my hypothetical, just involving the use of ordinary, old-fashioned blood pressure and related kinds of lie detection. So the question about under what circumstances we'd want to use this is not just about neuroscience. In much the same way, it's also about the kinds of things that Barry was talking about. It may not just be about lie detection. It may be about a whole range.
I have to tell you, there are many practical applications. I'm in Hank's camp, by the way, on this, because I'm really afraid that of anything in this area that does not have the kind of science. I'm afraid of bad science, period. Okay? But this has enormous practical implications, because I'm sure Jed has done this. Very frequently, prosecutors will change a decision. If you give a client a lie detector test and you go to them and you say, well, it's a child sexual abuse case. Who knows who's telling the truth here? Let's put them on a box. And that is done all the time. It's even worse. I think the slide was up from the fellow from CFOS where he said it has military applications. Well, the United States government and the military is using this stuff all the time. And we had a huge scandal with voice stress analyzers, which, was total nonsense. And we had the government using this in very important applications on espionage and all kinds of things. So don't in any way think that this isn't going to be used. It's being used.
Just to follow up with that, the Second Circuit Court of Appeals, in a decision which I think was totally wrong, allows probation officers, federal probation officers, to make determinations based on polygraph test, saying in effect, well, it may not be good enough to determine guilt or innocence, but it's good enough to determine probation issues. Well, probation issues are often where real time is determined as between jail and release. So it was, I think, a very unfortunate decision.
Yeah, and frankly, in New York State, I can't speak to other states, maybe others would know. In New York State, convicted sex offenders, when they're reporting to parole, they're all required to take polygraphs about their activities.
So, not to sort of continue to pile on Fred, but so I guess I'm clearly sort of in Hank's camp and with respect to this issue, and I wanted to sort of take up one of the last things you said, which is about what the nature of the concerns are about the validity. And one, you expressed this as surrounding whether the lab-based experiments, they're about instructed lies. In the real world, we're not talking about instructed lies. And so, is that the fundamental problem here? About a year ago, part of the MacArthur sort of project, and Jed and Mike Kazanaga's judge's guide to neuroscience, I took a moment to sort of read the 30 or so papers that were published up till through May 2009 on fMRI lie detection. And those papers are frequently used, and I do regret that Lakin, I don't believe, is here, and so this is perhaps a little bit unfair. But those papers are frequently used to make 2 points. One, as Dr. Lakin made yesterday, look, across these studies, there is consistency in the brain regions that are engaged. 2, of the 30 papers, in the 11 where you can say something about sensitivity, specificity, something about the reliability. The reliability is above chance, in somewhere in the 70 to 90 some odd percent. And you've appropriately sort of highlighted, well, there's issues of reliability, but there's also issues of validity. As I read that literature, and as I went through reading that literature, the laboratory-based experiments are not problematic or lack validity simply because they're about instructed lies versus not. It's because the context in which it's the things over which subjects in those experiments are to lie about are different from the things that they're supposed to tell the truth about. The stimuli that subjects are to lie about are associated with, and the way the experiments are done, rich autobiographical experiences. They get also tagged often as being particularly relevant or important or salient stimuli. And 2 papers in the last year using those exact experimental procedures, holding everything constant, except when you then get to the critical scan where people are asked to are instructed to lie or tell the truth. If you eliminate even that phase of it, eliminate the need for instructed lie versus instructed truth, and just have people watch the stimuli that for the group that was instructed to lie versus tell the truth, those are supposed to lie about, they elicited a different, bold response than the stimuli that the other group would have had to tell the truth about. The procedures are structured such that there are fundamental confounds between memory, stimulus salience, and attention, such that as I read the literature, I'm agnostic. I actually think in the long run, one will be able to crack this and one will be above chance. How far above chance, I don't know in terms of fMRI lie detection, but I think you'll be above chance. But as I read the literature, every published data point that says anything about sensitivity, specificity, is off point because it suffers from fundamental confounds. It's not clear it has anything to do with detecting deception versus detecting telling the truth versus detecting a rich memory versus et cetera. And so I don't think there's a single data point out there that would allow me to imagine going on a stand and saying, this is the reported reliability.
And if I were a judge, I wouldn't let you. That is part of what I'm saying. The biggest part of what I'm saying is not about we should admit this now. It is about the question of whether the legal system should outsource the ultimate determination to a scientific process that in many respects has different goals. The question of what should a journal publish is different from the question of what are the standards to give someone a grant, are different from the standards of whether a scientist should get tenure, are different from the standards that the law might use in some number of other areas. That's basically the idea here. It's also, though, the question of when we have experiments like the ones that you've just listed that are, as a matter of construct validity, somewhat too hugely removed from what we are really concerned about. In many of those areas, it would be nice to know more than we now know about what is the relationship between the admittedly different experiments and what it is that we might want to know closer. That is, that's the view that construct validity itself can be subject to measurement and is a variable. Now, again, you and I don't disagree at all about the current state of the evidence. I think we may disagree about who is going to give the final yes or no decision about whether and when this is usable. Yeah. Although out there in the literature, there is a fair amount, not from you, that does reinforce the view that the scientists don't think it's good enough, therefore the law shouldn't use it. It's that therefore that concerns me. And that you see from Liz Phelps, from Nancy Canwisher, from some number of others. And it's that therefore that troubles me a little bit.
You're angry on the good enough. I guess I'm angry on the science doesn't exist at all.
Yeah. Right.
I'll try to just extend it one step further and make a larger point that probably we do disagree about, which is, in terms of how science works, it's not, I understand the difference about the idea about two different thresholds of interest and propensity. But in terms of how science works, it's usually not the case, and often not the case, that, well, we're 70% sure, and now we're 80% sure, and now we're 90% sure, and pretty soon we're going to be real sure, and then you'll be able to admit it. It's usually the case that we just don't know. The experiments are bad, and we just don't know. And it may look like there's partial evidence, but so I'm just saying that there should be some real caution in terms of how science works. Right? My worry is if you're making the decision, I want to make sure that you have the right kind of way of evaluating it. Because it's more often the case that we just don't know yet, not that we're 75% sure.
One of the things that I found so interesting about this conference is, and I can divide it very crudely into two categories, the utility of neuroscience in determining factual issues and the utility of neuroscience in telling us what we ought to do about things like criminal responsibility, sentencing, and so on. And in some ways, the neuroscience is much easier to understand how to use when it's just telling us facts. Right. For example, if it can tell us more about pain, once we know the facts that we learn about pain, we've got a system that will tell us what we do with those facts. And in that sense, your neuroscience is actually tremendously helpful and not very problematic. It may be not helpful and very problematic when it masquerades as fact, but it's not. It may be problematic when it increases the chance of something being true. If it were, for example, true that we could detect lies through fMRIs, which we can't, but with 70% accuracy, introducing evidence, okay, well, that's like introducing blood type. Okay, well, this is, 70% of the population have this. We put that in all the time. But then you worry, well, wait a minute, maybe lie detection with 75% accuracy will attach too much importance to it. So what I'm ending up with out of this conference is a sense that there's lots of fascinating stuff going on that is factually interesting. And my last comment would be, I love Joanna talking about shaken baby syndrome and the pathological evidence that you are able to get. I'm getting shaken baby cases coming back to me now on habeas where there have been convictions alleged to be wrongful, say 10 years ago, 15. I think I've had 3 of them in the last 2 years, and nobody's given me this evidence.
That's for sure.
All right, I think that brings us to a close. I want to both thank our panel and also thank Steve Kendall, who could not be here, and Anne-Marie Mazza, who is here, for organizing what I think all of us agree was a terrific conference. Thanks very much.